that the county, that the probate code has decided. And for instance, I'm married and have one son. If I die without a will, my son will inherit one half of anything I own, and my wife will inherit one half of anything I own. So that may or may not be what I want to have happen. If I had a will, I could say, well, I want my home to go to my wife, not be owned co with my son, who's 11, which would be problematic, right? Or I could say to my wife, for the duration of her natural life and upon her passing, to my son. So I sort of can make it flow the way I want. Now that process of taking property out of the name of someone who's died and putting it in the name of someone who's living, whether someone had a will or they didn't have a will, has to be taken care of by the administration of the estate in the probate court. So folks may have heard of the probate court. You may have dealt with them if someone's passed away, but the probate court is just the court that handles, generally speaking, for our purposes, taking property out of the name of someone who's deceased and putting it into the name of someone who's living. If there's a will, they're going to follow the will. If there's not a will, they're going to look to the probate code and what does the probate law say about who inherits when someone dies without a will. So either way, that estate administration has to happen through the probate court to create the record. So when we're talking about who owns property, right, you should be able to take any piece of property, the identification number for the property, the current owner of the property, and backtrack it all the way 100 years back, because it's going to go from recorded deed to recorded deed to recorded deed. And then when someone dies owning the property, you should be able to go to the probate court and find the record where they passed away and where that property goes. So there's what's called a chain of title, right? So a chain of title is simply the ability to track those transfers across time, whether they be by deed or whether they be by someone passing away and their estate being administered in the probate court. Those records are there in perpetuity. And, you know, back in the day, sometimes stuff burnt down and you lost them, but today a lot of it's reserved to cloud-based stuff. But in the end, that's how you prove who the owners are. And that's the ability to do that is what makes land accessible to the people who own it, right? Because if you're going to get a mortgage, you want to maybe get an equity line, or you want to borrow money on the land to build, or you want to, or you maybe even want to qualify for home rehab after a weather event through FEMA or some other programs. At the very base, they're going to request or require, okay, prove who the owners are. The problem happens is heirs property owners, in the way we serve folks, don't have the ability to show who the owners are. And the reason that happens is that somewhere along the line, someone died owning the property, right? There may be a deed into their name, but when they died, nothing ever happened with their estate. No one, whether they didn't have a will, and no one ever opened that probate court administration we talked about that creates the record of who inherited from them. So what happens is that person may be dead for 20 years, 30 years, and the last record is the deed into their name, because there was never a probate administration proving to the world by a public record who inherited from them. So very often with heirs property, and a lot of our clients, they'll come in and the tax bill will say heirs of John Smith, right? But John Smith's been dead since 1972, right? The problem is his estate was never handled. There's no record of who inherited from him. So the last record via the county, even the assessor and the tax assessor and the auditor, is John Smith's deed back in 60 something. He dies in 72. So it just says John Smith. They're aware that he passed away, but there's no record of who inherited. That's why it says heirs of John Smith on the tax bill very often. And usually you'll have a care of party, a CO party, whoever there happened to be sending the tax bill to, right? It's usually a family member, whether it be a, wife, husband, son, daughter, grandson, great grandson. When we're dealing with multiple generational heirs property, a lot of times we're dealing with a great grandchild of that original owner, and they've been paying taxes over time. So what does that all mean, right? I mean, what does that look like? What it looks like is when someone dies and their estate's not taken care of through the probate courts, there is no record who inherited from them. That doesn't stop the inheritance from happening by what's called operation of law. And that sounds a little odd. There's no record of it happening per the estate administration, but it happens. In other words, the example of me, my wife, and I have an 11-year-old son. If I pass away without a will or otherwise, and my wife never opens my estate, there's no record that because I didn't have a will, she inherited half and he inherits half, but they did. There's just no record of it, right? So when somebody looks at my tax bill, it says estate of Josh Walden or heirs of Josh Walden, but my wife has already inherited and my son has already inherited. The instant I passed away, under the law, those rights transfer. There's just no record that that's happened. Doesn't mean it didn't happen. So at the end of the day, here's where it gets really muddy. Let's say my wife passes away. Let's say my wife gets remarried, right? And this is land I inherited from, say, my father or my grandfather. My wife passes away. I have no will. So she inherits half, son inherits half. My wife gets remarried. Maybe she has children with a second husband. If she dies without a will, that second husband and the children she may have had with him, or maybe even children he brought to the marriage, will inherit an interest in my family's property because I passed away without a will. She passes away without a will. The law says, well, whoever she's married to, whatever she owns, which includes the one half she inherited from me on my family land, can go to her natural heirs, which would be her husband and her children. So it can turn into a situation where people own the property or have an interest in the property, and they have no relation, no blood relation, not even a marriage relation to someone who's blood, and therefore they have certain rights. And as time goes by and more people pass away, that group keeps getting bigger and bigger and bigger, and it becomes really problematic. Not that it's not problematic when there's 5 people. If your family's like mine, it can be a challenge when there's 5 people, but you can imagine what it's like when you're dealing with 75 people, right? Or more. And you're trying to get an agreement to move forward and try to clear title to the property or resolve that problem of there being no record of who the owners are. So that's sort of the way things set up for heirs property. An absence of wills, the absence of access to trusted legal resource and affordable legal resource. Sometimes it's not just about people not knowing what to do. It's maybe I know what to do. Maybe I don't have the resources to hire an attorney, or maybe I don't necessarily trust the attorneys in my area, which is definitely a common theme that you sometimes run into, particularly given not only the history, but the ongoing predatory development and nature of heirs property. Okay, so I suppose a question, and I'll break here real quick. Does anybody have a question based on that sort of foundation of how heirs property sort of gets created? Okay, and I assume either someone will put it in the chat or just sort of do a hand up and we'll go to you. So if there's no question about that, so what does it look like once that's happened, right? Once someone's died owning the property, in South Carolina, you have 10 years to open the estate after someone dies to do a relatively simple estate administration. So what does that mean as far as the owners, this group of people who have inherited? What are their rights? Okay, well, those heirs are what's called tenant in common. That's the form of ownership they have. And a tenancy in common form of ownership comes with certain rights and certain limitations. So, and a tenancy in common form of ownership is not just about heirs property. It's the law that's sort of the default anytime more than one person owns land. Alexa and I could go buy a piece of property together. We would be tenants in common. Okay, so this isn't an heirs property law so much as it is a multiple people who own land together, multiple owners on one piece of property. Unless they choose otherwise, it's a tenancy in common. And what does that mean? And this is what this form of ownership and the rights associated with it are what's made heirs property so vulnerable to forced sales and families losing their land. And I'm going to go into how that and why that's a problem. a tenancy in common basically is broken down into everybody has equal rights to use and enjoyment of the land as a whole. And it doesn't matter what percentage they own. Okay. So let's say we're in a situation where there's 10 acres and 10 heirs. So common sense would be, okay, everybody owns an acre, right? Particularly if some folks already have a home out there. Maybe they've even had a survey that cut out an acre and they got their house there. And maybe even the county's given them a different tax map number, but all the property's still in the name of their great grandfather or their father or their mother. So it's heirs property, like we defined earlier. So what that basically means as far as their rights is these 10 heirs on 10 acres, they each own 1/10 interest in 10 acres. They don't own an acre apiece. So everybody has use and rights to enjoyment of the whole property. Now, as you might imagine, as those original 10 pass away, maybe they have an average of 5 kids a pop or 5 people that inherit from their line. 10 turns into 50 really quickly, and the land don't grow with the heirs. The land stays 10 acres, right? So as heirs pass away and as heirs maybe don't have wills or don't have estate planning, that group gets larger. And so sometimes folks can get fooled into thinking that their heirs property's fixed because they got a survey and the county gave them their own tax bill for 1 acre. Very often, now there can be a false sense of security sometimes in that regard. But again, those people each own 1/10 interest. So rights to use and enjoyment as a fractional owner. And it doesn't matter what your fraction is or percentage of ownership is, by the way. Saw a chat.
Yes, there is a question in the chat.
Okay, it is recommended to buy land or property as a couple or individual. That would really depend on your circumstances. Very often, if it's a couple or if it's a married couple or otherwise, there are ways you can, unless you instruct the attorney drafting the deed that you want it in something other than a tenancy in common, each of you owning 50% if it's 2 people, then it's going to be that way. Now there's all sorts of mechanisms you can ask and request. You can ask that it be a joint tenancy with a right of survivorship. So if Alexa and I went and bought a piece of property together, we can make it where each of us own 50%. So one of us dies, that 50% is going to flow through our own estate, subject to our own individual will. Or we could have a joint tenancy with the right of survivorship. So if I get hit by a bus, Alexa owns it all. Or if she gets hit by a bus, I own it all. It's another form. Very often people have just a tenancy in common where they each own 50%, but they have wills that basically take care of those interests after they pass away. Personally, my wife and I, as far as our home, we've got it as a joint tenancy with the right of survivorship. So when one of us passes away, once the other one produces a death certificate, that interest has disappeared. It's fully vested in the other one without having to go through the probate process in the probate court, like we talked about at the beginning. So yeah, it depends a lot on what your individual circumstances and what your ultimate goals are and the relationship you have with that other person. Because sometimes being married is different than having a significant other who you may not be married to, or just a partner in a business transaction, or just someone that you a sibling or someone that you just want to own property with. There's certain things that come along with owning property with someone else that can prove problematic down the line. So you always want to get all the options as far as what that looks like if you're buying property with another person. So hopefully that answered the question. So the limitations on this form of ownership, like we talked about, you have multiple owners, you have no public record of who the owners are, even though you have a group of owners who have inherited by operation of law. That's basically the law as it's floating in the air and dictates what happens when someone dies. That takes place, even to the effect that once we're trying to resolve the problem by way of a court process, we're providing evidence and reiterating to a judge how this all happened over the course of time, leading up to an order signed by the judge that basically makes of record what's happened since the person originally died, the original owner died. So that's sometimes what we're talking about problem wise. And I'll say this, a lot of times when people think about heirs property, I think it's important to remember that heirs property isn't just a number of acres somewhere. Heirs property can happen at any time. All it takes is someone dying without a will. It can be clean property, fully accessible to the owners. If someone dies without a will or with a will, and the estate hasn't been opened inside 10 years from their date of death, creating the record of who inherited from them, after 10 years, you can't do a simple estate administration. You've got to bring either a petition to determine heirs in the probate court or a quiet title action, usually if it's multiple generations of this sort of inheritance that have been going on without any kind of estates being established or creating the record as each person died in the probate court. Looks like we have a question. My aunt is 93 years old and the only living child of my grandparents. Is she considered an heir of the same level with the many grandchildren? She has a will. What she needs to do with her property rights? Well, that is one of those wonderful questions that you really need to sit down with an attorney and have a one-on-one. I will say this, if it'll depend on the law of the state. Not all states have the same intestate law. And it also depends on when folks died, because the law in South Carolina changed in roughly 85, 86, as far as who inherits without a will. So if the property's in South Carolina, I'll go ahead and say that anybody in South Carolina can call the center and get a free consultation with a center attorney. Now it's got to be in South Carolina. And for legal services, for the legal aid component, where you can qualify to have an attorney take your case and handle it for you and help with the family, the property has to be located in our 25 current county service area. But anybody in the state can call and get the free consultation with an attorney and get some solid ground and speak with an attorney for an hour and a half about your specific circumstances and provide paperwork to be reviewed and that sort of thing. So the reason I don't touch those kind of questions is because the devil's always in the details. There's a ton of questions I'd have to ask. It would probably take the rest of our time for me to give you an answer that I'd feel comfortable with and not worry that I told you something that might be incorrect. So, but if the property's in South Carolina, certainly give us a call, or, before we go, I'll leave my email address. And if anybody on here has a question or something like that, they can certainly feel free to email me directly. And I will either answer the question if I can based on the email, or I'll put you through to the legal department and have someone call and set up an intake for you if the property's in South Carolina. So if you have a question like that, certainly feel free to email me. I guess I'm going to give my email, or you type faster than I do, Alexa. Can you put my email? I'll put it in there and it'll be jacked up.
It's in there. You're good, Josh. I've provided the center's phone number and your email.
Thank you. Thank you.
You're welcome.
Great. Thank you, Alexa.
So the idea of, if you have property that's free and clear, you and your husband bought it, or you and your wife bought it, and you have, and regardless of what state you're in, you need to have a will. You need to have a will, and no one likes to talk about it, and it makes you feel a little uncomfortable. And I know I've been practicing law since 2000, and it's just recently I even convinced my own mother to get a will. She doesn't even like to even talk about it. So having a will lets you decide what happens. You're not leaving it to the state of South Carolina or your own state to determine who inherits from you. That whole example I got, I don't have any family land, but if I had family land, I can promise you that I have a will, because if my wife gets remarried, I don't want a second husband inheriting part of my family land. So that wouldn't happen. So this is sort of what we're talking about, that problem with heirs property. Now, I kind of want to talk about some myths that come through our office a lot about what people think is true about heirs property, and it can lead to some decisions that actually make a family more vulnerable. So some of them are, and some of you may be amening these as we put them out there, because you maybe hold them or you've heard them. But I pay the taxes, therefore I have more authority over the property, right? So almost every family I've ever worked with, every case I've ever handled, taxes can be an issue, because sometimes you have people who are bearing the burden of all the taxes, or a small group of people bearing the burden of all the taxes. And some folks don't, either they can't or they're unwilling. and that can create tension in any family. And sometimes that is a problem. But what I tell folks is, and when we're having a family mediation and we're at a church or a community center on a Saturday and the whole family's there and people are voicing their problems with each other in the situation, what I tell them is, doesn't matter who paid the taxes. You should thank the person who paid the taxes, because but for that, it would be gone and lost via tax sale, which can happen certainly with heirs property. But they don't gain any substantial rights, and the people who didn't pay don't lose any substantial rights ownership wise by not paying taxes. Certainly the property would be gone but for someone doing that, but it doesn't increase ownership or decrease ownership regardless of how you are involved with that. Another thing I spoke to a little earlier is sometimes people have a survey and they think that's separated their piece, right? So that 10 acre and 10 acre example I talked about, they get 1 acre survey and the county goes, wonderful, we recognize the survey, you've got a new tax map number. So, and they might even put it for tax purposes in your name. That does not separate it from the other 9 owners. That survey is just a map that the GIS county will use. And sometimes they used to do it all the time. Now a lot of counties won't even do this. But once that survey is accepted and approved, then it'll be shown as a separate piece of property. But for ownership purposes, those 10 heirs, the one who got the survey and lived there owns 1/10 interest in that 1 acre, and the other 9 own 9/10 interest in that 1 acre, just like that person owns 1/10 in the other 9 acres. So it doesn't separate for purposes of ownership, only for taxation. Another one that I've seen happen a lot, which is really dangerous, I've actually seen people suggest to heirs property owners, well, let it go to tax sale and then buy it at the tax sale and you'll get a tax deed. Well, that tax deed, there's 2 problems with that. One, if you let it go to tax sale and someone bids on it and maybe you can't redeem it, then you could lose it that way. Someone just outbids you. Or depending on what county you in Dorchester County, South Carolina right now, if a property sold at tax sale and it's heirs property, unless the title is resolved via a court order, they won't allow an heir to redeem the tax sale. So in essence, in Dorchester County, if a piece of heirs property goes to tax sale and they can't prove their owner, and remember, with heirs property, you've got to have some sort of legal process that creates the record of who the owners are, because that's the problem with heirs property. There is no record of who the owners are. And that process can take anywhere from a year if it's extremely simple. I've got one up for trial this year that I've been working on for 6 years. So it's almost impossible. So one, be sure you know what your county's stance is on it, because Dorchester County is the only one that's doing that right now. But you could lose it, and then even if you let it go to tax sale, even if you get a tax deed, that tax deed is what's called a quick claim deed or a quick deed. That's the type of deed it is. And the quick claim deed or the quick deed basically says any interest I own, I'm giving to you, right? So if I own my house and I give an Alexa a quick deed or a quick claim deed, then she owns it because I own my interest. But I could give Alexa a quick claim deed for the office building that we work in, and I'm not guaranteeing her that I own it. And if I didn't charge her anything, she can't sue me necessarily for fraud because I didn't induce her to give me a payment. A quick claim deed only transfers whatever the person owns, but it doesn't guarantee what the person owns. Like when you buy a house, you get a general warranty deed. A general warranty deed says the seller is telling you by the language in this deed that I am the full owner. And if someone challenges the ownership, I will defend the warranties I'm giving to you that I'm transferring 100%. A quick claim deed, which is what a tax deed is, says whatever this is, whatever I got, it's yours. So if it's 100%, you got 100%. If it's nothing, you got nothing. So a quick claim deed is a valid deed. It just doesn't come with warranties for the person who signed it to. So a tax deed does not resolve heirs property. You still have to go through the same legal process as an heir once that tax deed is issued. The other ones are the other myths have more to do with sort of the family dynamic, and sometimes what we run into when we're, because the center has, since 2005, I think we're about 320 cases resolved since then at roughly $20+ million of tax assessed value. And we've never been involved in a case where a family lost land. And that's one reason we can say that is if we're bringing a quiet title action, which is one of the ways you resolve sort of the more complex, long-standing heirs property, we are going to negotiate a family agreement. We don't accept cases where heirs want to sell property. Not that that's not in a family's best interest sometimes, but we're in the preservation business. What we want to do is provide legal services to folks who want to keep their land, but don't have the resources to pay an attorney $350, $400 an hour, $30,000 over 3 years for legal fees, right? And to that, again, that's what we're about. And if you're going to do that and do it at the successful rate we have, where we've never been involved in a case that ended in folks losing property, you got to be able to mediate, and the family's got to be able to come to an agreement, because we generally won't put someone in front of a judge if there's not a family agreement. And one thing I want everyone to remember, no matter what attorney, and I'm talking South Carolina, no matter what attorney you're speaking to, if you're working with a private attorney to resolve heirs property, make extremely clear to him or her that your number one priority, if this is the case, is to be sure the land is not placed in jeopardy. Because if you don't have 100% agreement amongst all heirs and you're sitting in front of a judge, you are to some degree vulnerable to a forced partition sale. And I'm going to explain how that works, what a forced partition sale is. The idea of, and a couple of other myths I'll throw in there. Who inherits? Sometimes people think only a blood heir can inherit, right? And we talked about how that's not the case. Second husbands, second wives, children completely unrelated to the family tree can inherit just by people dying without a will. The other thing who generally inherits it, sometimes people have a question, is outside children. Children outside of marriage more often than not do inherit, right? And sometimes when we're working on a family tree and we're working with a family, sometimes those folks get left out. Sometimes purposefully, sometimes just people forget. But what I always tell them is, we kind of know, if you're like my family, you kind of know who those folks are. And you know, if they show up at the funeral and they're looking just like the person in the box, we all know we need to include them on that front end, because what we don't want to happen is them to show up in court when there's a public notice in the paper, as is required anytime you're going to resolve an heirs property situation. We want to deal with those folks on the front end because we have some control over it, right? But what we don't want is not to know they exist as your attorney, and then we're the day of the trial, we think we've got everything squared away, and somebody pops up and they can prove that they're a child, and what's furthermore even worse, they show up with a lawyer and they're mad because they felt they were left out on purpose, whether that be the case or not, and then they could force a partition sale. Another thing is the court actually did away with common law marriage in 2019. Now, the common law marriage can happen prior to that order, to that recent order, but there is no common law divorce. If someone is separated from someone for 50 years, if they did not get a divorce, they are still the spouse of that person. They're still your husband, still your wife. Doesn't matter how long you've been separated. So when you pass away, and you pass away without a will, guess who inherits 1/2 of everything you got? That wife that you know you left, or that husband you left, or y'all mutually agreed to separate, and they're in another state, or they're 2 blocks away, and you haven't cohabitated or had any kind of relationship for 30 years. The law doesn't care. You're married, and the only way to become unmarried is divorce. So we've seen that pop up several times, and ask people, where's the divorce decree? Well, we're divorced. Well, where's the divorce decree? Well, we didn't really divorce, we're separated, which changes everything. That example I had about my wife inheriting family land. Well, if I'm divorced from my wife, I don't have to worry about that. But if we're just separated for 50 years, she's going to inherit that same 50%, right? So we want to be knowledgeable of that. So when you're constructing that family tree, which is the first thing we do with a client, we got to come up with a provable family tree locate everyone, because we got to prove to the court who inherited, right? We got to provide evidence to the court as to who inherited. So, you know, if as we sort of go through these problems, hopefully what it does is if you have heirs property, you understand that the sooner you try to attack that issue, the better off you are. As difficult as it is right now, it'll never be easier than it is right now, because as people pass away, that group keeps getting bigger and bigger and bigger. And often what happens is people inherit who have no family tie, no feeling for the land, anything outside of anything other than its value monetarily, right? There's no emotional tie to the land. It's not like it is when we walk with a client on the land who's 83 and she grew up on that land. She talks about it very differently than when I'm talking to someone who's a fourth generation person who lives in Philly, who inherited and owns, you know, a small fractional interest. They look at it entirely differently, as you would expect, right? So the longer that goes, the more vulnerable it becomes, simply by the fact that people don't value it the same way. So what are the dangers of heirs property? Why do you even want to mess with it? Because it is a difficult, the bigger it is, the bigger the group, the longer it's been this way, the more difficult it is to resolve usually. There's a lot of sweat equity put in by the family. When we work with a family, the attorney does a lot of work, the family does a lot of work, and getting that agreement, it can be difficult. Finding everyone can be difficult. So why do it? Right. So I'll just leave it the way it is, or I'll let the next generation worry about it. The problem is this: a lot of land, a lot of African-American land has been lost through predatory development and partition sales, forced partition sales. And here's how that happens in heirs property. We talked about the 10 heirs and the 10 acres, right? So outside of all the other fun stuff we talked about that's problematic with it, trying to get it divided and that sort of thing, here's the other thing that's a danger. Any one of those 10 heirs, any of those 10 heirs can sell their interest to anyone. So if we've got 10 heirs and I'm a guy that lives next door and I own 50 acres, and this 10-acre piece would just be beautiful if it was attached to my property, right? So let's say one of those 10 heirs is local, or one of them lives in Philadelphia. We'll just pick on Philadelphia. One of them lives in Philadelphia, and I want to buy their interest because I understand how the law works. So if I buy an interest of one of those 10 owners, that group has a new family member. It's me. I own the 1/10 owned by those people, by that brother or sister. So now it's 9 family members and me that own the interest in the property. So, all right, what's the big deal? Well, what's the problem there? Well, I didn't do that so I could come to the family reunion and come out there and hang out on the property. The reason I did that was intentional. It was to bring a forced partition sale. And that goes back to the rights everyone has in regards to heirs property. So each one of those 10 heirs or tenants in common, like we talked about, they have use to enjoyment of the whole property. Nobody owns a piece, everybody owns their percentage. I buy the percentage of an heir, I become part of that group of owners, that group of tenants in common. I have the same rights that any other heir has in that property. Those rights include to sue the other heirs and request the court sell the property and the money be divided equally amongst us in accord with our respective interests. So if I'm doing sort of the historical predatory development move, I buy my way into that group of 10 heirs. I'm now one of the 10. I sue the other 9 for in the court, in the Master and Equities Court, for what's called a quiet title and partition sale action. So I want the court to confirm that we're the 10 owners. I want the court to find that we can't agree to divide it up physically. So the court will sell it, and then everybody get their respective interests based on money, the sale price allocated to them in their respective interest amounts. But my ultimate goal is to buy it at auction or buy it at the sale. So I become the full owner. So a lot of land, particularly land along the coast, particularly land that at one time wasn't that valuable because of mosquitoes. Once the mosquito control became something that wasn't such an abstract idea and people could actually manage that sort of thing, and malaria wasn't as prominent as it used to be, those formerly tidewater, low country properties that a lot of times were sold to African Americans or folks on lower socioeconomic resources became extremely valuable. Now they make great places for golf, golf courses, walled neighborhoods, that sort of thing. So this buying their way into family held land in the heirs property form of ownership was a way to disenfranchise and pull property out of folks. Now, sometimes, and that's not a historical thing in the sense that it doesn't happen anymore. There was the passage of the Uniform Heirs Property Partition Act in South Carolina. So it does make it harder for a developer to force their way in and then force a sale. Doesn't make it impossible. It in no way makes it impossible. So that should not be seen or considered a proof or a safeguard against that. But at the end of the day, it does make it a little more, it gives the judges a few more considerations as far as deciding on a case like that. But that's how people get forced into sales. And sometimes the heirs who are living outside the state, they receive a letter and they have no reason to know that that's what's going to happen, because people prompt them and say, listen, I want to buy your piece. One of those 10 lives up in New York, and they get a letter saying, I want to buy your piece of this 10-acre property. Well, why would they have a reason to think that they're selling anything other than 1 acre that they have a right to? Remember, they don't own an acre, they own 1/10 and 10 acres. So that's how people get tricked into signing a deed where they would never have done it had they known that the outcome was going to be that the heirs who actually live on the property could be forced off by way of a forced partition sale. So those things are, those are realities. And another thing that's a reality that I see just as much, if not more, than the developer trying to worm their way in is intra-family dynamic, resulting in heirs suing other heirs to force a sale when there is no developer. It's just a matter of disagreement. It's a matter of different land ethics or perspectives given you where you fall in that family tree. Like we talked about, if you're one of the original children of the original owner, or even a grandchild of the original owner, and you're dealing with a group of heirs who have never set foot on the property, or maybe even in the state, except for, the occasional family reunion, they're going to look at it really differently than that. And as that group gets larger, it's more likely that that's what's going to happen. And also, as the group gets larger, the land doesn't grow. So the ability to come to an agreement, if everybody wants to have a piece, becomes much more difficult as the number of people grow and the land stays the same. So again, that sort of time component about addressing it, it's certainly not an easy process, but it is something that needs to be considered when you're deciding whether you want to broach the subject. Now, one thing I'll say is that the center has this sort of unique service. And again, this would have to fall within the 25 counties we serve as far as full services. Again, anyone can call and speak to, and set up an appointment to speak to an attorney about an estate issue or an heirs property issue, regardless of the county they live in, as long as it's in South Carolina. But if they're in the 25 county service area and they have a qualifying person, and we need one family member to qualify based on the income criteria, because we are a legal aid organization, we don't charge for attorney's fees. Clients generally, or families usually, pay for the cost, whether it be filing fees or a survey if they need one. They never pay attorney's fees. But as people, sometimes people will come in and they say, well, we got some family disagreement, which if you come in and say you don't have family disagreement, the first thing I think is, well, either you don't know about it or you're fudging, because I've never met, including my own family, getting together on something this big and not have some level of disagreement somewhere. But that doesn't scare us away. All of our attorneys, part and parcel to what we do, is understand that we're going to spend a lot of time with this family. We're going to spend time sometimes on a Saturday at the church or at a community center with the family and talking about how to work this out, what the opportunities are, there's more than one way to skin a cat sometimes. And when folks know, one, these myths are dispelled about who has authority versus who has perceived authority, and what the possibilities are. Sometimes folks can talk about rightful wounds and things that matter and truly do matter, but getting past that to the point of what's in the best interest of all of us, and for a piece of property that we did nothing other than be born to have an ownership interest, right? We can get together. So I've personally started I've started with a client and we had to meet with the sides of the family at different times, one Saturday at one church and one Saturday at another church, because they didn't want to be in the same room together. So that kind of stuff does not scare us. We look at it as something that's sort of part and parcel to trying to resolve it. So don't let that be the reason you don't call us. Now, if you come in and you say, we got a big kind of issue that way, and we want everybody to hear sort of what you do, we got this thing called a family presentation, where the initial engagement with the center attorney is they just come out at a perceived date and just talk to the family and give them a seminar, sort of like what we're doing today, but make it customized to their particular circumstances, and also let the family sort of talk about things. And sometimes it gets heated, but sometimes it needs to get heated in order to get to the other side, come out the other end, and get to the end result. I'll say that, you know, our attorneys have our attorneys have a luxury that private attorneys don't have, and that's this: our attorneys are paid by the center. They're not paid by the client. They're not paid by some third party. They are employees of the center, and we don't accept cases where folks want to sell or sue another attorney in an adversarial way. We can allocate 6 hours on a Saturday, driving there, staying there for 2 hours. A private attorney would have to charge so much money, even if they were willing to do it, that it would almost be impossible for a family to keep up with those costs, in addition to just the legal costs of the legal work. So I think one of the reasons we have as much success as we do, and when I say success, I'm talking baseball success. If we can bat 300, we feel like we're doing really good, because every family is different, and sometimes things may not work out family agreement wise, but that's because we have the time, and the type of attorneys we hire have an inclination towards our mission that Alexa talked about. And first thing is, we want to do no harm. Secondly, we want to respect families and go through this sort of time-proven process that we've used to try to get folks and families to the other side. I see another question. What about squatters' rights? That's a great question. And you know, Alexa, you know me, I'll just keep talking. Tell me to shut up if I'm going too long, or we need if we're running out of time, just let me know. But squatters' rights are basically adverse possession rights. Okay. So adverse possession is a legal doctrine that says, if I live on your land long enough and you don't stop me, then after a certain period of time, I have gained an ownership right, and you have lost or acquiesced your ownership rights by inaction. So there are two kinds of standards. There's one when people aren't related and aren't tenants in common, and there's another standard for when people are related, right? So let's say, you know, Alexa owns a piece of property and she don't know me from Adam, but she never looks at it. She never goes by there, and I go there and I put some sort of home on there, and I've been living there, and it's open and notorious. So anybody that drives by that land can see me out there, right? She can see me out there when she drives by, but she never does anything, right? She doesn't do anything, and I claim to own it. If somebody asks me, I go, yeah, this is my house. This is my home. It's my land. Well, after a certain period of time, the court recognizes that I may have a right, or I may have created a right, and she may have lost rights because she slept on her rights. So that's how people acquire property by adverse possession. There's a statutory and a common law time frame. Statutory, I believe, is 10 years. Common law is around 20 or so, but there are certain criteria or things that have to happen. Now, here's the problem with heirs property. Like, we'll go back to the 10 heirs. I know I'll wear that 10 heirs and 10 acres out, but to me, it's the math is easy. So that's why I use 10 heirs and 10 acres. But if you got the 10 acres, and let's say one of the heirs gets a survey, like we were talking about, and cuts out an acre and builds their house, and they say, well, wait a minute, I've cut this 1 acre out. I've built my house here. So if I'm here long enough, I should have squatters' rights or adverse possession rights as against the other heirs, right? Not some person I don't know or don't know me, but against us. Now, we don't bring those kind of actions because, again, we don't handle adversarial actions amongst heirs. The problem with that is there is a much higher standard for proving adverse possession amongst family members, because at the core, everybody has the right to use all of it. So how can you adversely take or take against the will of someone else something you already own, right? Now, it doesn't mean that that hasn't been successful as a cause of action in the past, but usually it's either so extreme that it's really hard to meet. It happens to be open, notorious, against the rights of the other folks, and it has to rise to what's called a level of ouster amongst co-tenants. That's something that's so extreme amongst family members that very often you can't hit that unless you're going to build 13-foot walls and put gun turrets on the side. You already own an interest. So how do you take something you already own? Right now, I've seen it be successful, not by case we brought, but in the past because nobody showed up to contest it. Right, the other heirs just saw it published in the paper, didn't do anything. That they're there, nobody else is there. Judge signs off on it. Boom, they got an adverse possession cause of action. That don't happen very often. And here's the danger of it. Let's say you do that, hoping that nobody shows up. Well, maybe the other heirs do show up. And not only do they defeat your adverse possession claim, they countersue for a forced partition sale. That's a danger, right? Anytime you sort of open that Pandora's box of adversarial actions against other family members, it can happen. Not saying that adverse possession amongst tenant in common heirs can happen. It certainly can, but it is a high bar. And that's sort of, we don't bring those kind of actions, but I have seen them brought. But I guess also from a non-heir standpoint, if somebody moves on your property or is using your property or doing something like that, you need to, one, let them know you know about it. You need to either have them stopped or you can give them limited permission, which defeats the adverse component. Like if somebody is a little over my property line or something like that, and I don't want to go through the point of suing them, I could just write them a letter to the effect, and this is South Carolina law, by the way. I write them a letter saying, I acknowledge that you're there, you are over the property line. I'm giving you permission until such time as I'm telling you to leave. That defeats the adverse component of that cause of action. So folks generally have a harder time proving it because I gave you permission. It's kind of counterintuitive, but it's one of the ways you can look at that. I'm looking.
Josh, you have about 5 minutes.
Thank you. So as you could probably tell, I love talking about this topic and I love answering questions. And so does anybody have any additional questions I can answer or anything they want to bring up, or maybe anything that you want me to comment on in any way? I know that's a lot of information in a very short period of time. So
Excuse me,
have my
Josh, I
email.
do have a question.
Yes.
Real quick, a little while ago, you mentioned something about after 10 years, a quiet title action or a forced. Could you repeat, if you recall what you said? If you could repeat that, I'd appreciate it. Thank you.
Yeah, certainly. In South Carolina, when someone dies, whether they had a will or not, you have 10 years from their date of death to open an estate administration in the probate court of the county wherever they own property or they lived, their permanent residence. So that's, again, the first level of creating that record of ownership. So, but once 10 years passes, if someone died 10 years ago in a day, I can't go down to the probate court and open an estate in that sort of traditional estate administration. And that process is really form driven. It can be rather, I won't say simple, but it's a lot simpler than the other outcomes. Now, after 10 years, the thing that happens is you can't go the route of normal estate administration. You have to bring an action that puts you in front of a judge with witnesses and a courtroom and a court reporter, a much more detailed process. Now, here's another interesting thing. A will, after the person's been dead 10 years, if the will was not filed in the estate open inside that 10-year period, it is considered void. That will is no longer valid. So it reverts back to the intestacy or the will. The probate code is written for everyone. So if someone dies with a will, that will has to be administered in the probate court within 10 years of their date of death, or that will is void. It's as if they died without a will. So that's an important component too. Generally, after that 10-year period, our folks are dealing with determination of heirs actions in the probate court, or if it's multiple generational heirs property, there's been 2 or more generations who have passed away with no estates, we bring a quiet title action because you can address more generational stuff in one action than multiple actions in the probate court. So so that 10-year line of demarcation is really about filing the will and estate administration in the simplest form, if that answers. So we got another
Thank you.
question. Sometimes families are tentative about starting the process because they do not have much disposable cash on hand. Approximately how much should one have in pocket to get started, and typically what a general cost to complete the process? Woo, that's a loaded question. It can depend on where you are and what you're doing. If you're working with a center, you don't need anything. I mean, if you're working with a center in South Carolina and you got a qualifying heir and you're in our 25 county service area, then the first cost that usually comes up is a title search, but putting the family tree together, doing that other stuff. Now, if you're working with a private attorney, a lot of times they're going to ask for a retainer of some kind. It can be extremely expensive, particularly if it's across multiple generations, because just the time it takes to handle it as an attorney and the man hours. I know most of them are going to want. I would have a strong conversation with any attorney that I'm being interviewed, who I'm interviewing, because they're going to be working for you. They got to meet your criteria, right? So you need to say, well, how much, if they're asking for $5,000 retainer, you're asking, what does that look like? What if we run out of retainer and we're no closer, or we're only slightly moved because we've been working on the family tree and some other things? It's one of those things. Yes, Sumter is in our 25 county area. So certainly call. That was a question. Somebody said, is Sumter in the 25 county area? So yes, Sumter is. I'll try to name all those counties in a second, or maybe Alexa cut and paste it, put it in the, but if you go to our website, you'll see we actually just moved into Richland. We're moving into Richland, Kershaw, and Chesterfield in April of this year. We are on pace to move into Lexington, Barnwell, and Aiken in 2024.
Yay.
So
Awesome.
we're hoping to be headed that way. You know how those attorneys are. They're hard to hire. So we got to raise money to have them in the house along with the foresters. But so that it's really hard. I could tell you that it's not uncommon in working with a private attorney, particularly if people are trying to force a sale, that attorney will get a substantial amount of that sale proceed if they're willing to do that. Very often they won't cost up front. They don't take it on a contingency fee. So it can be just, you got to be really intentional about interviewing the attorney you're going to be working with, and make clear to them what your ultimate goal is. And that if ultimately you want to tell them, whatever you do not put me in a situation where the property that I've initiated an action that could result in me losing this property. Because there are safeguards you can do to be sure that doesn't happen.
Josh, there was another question. What if the estate is not officially closed? Is any land interest at risk?
If the estate has been open through a probate court and that administration is ongoing, the interesting thing about probate is usually what's happening is that the only time property can be, well, I shouldn't say the only time. When someone dies and there's property, it depends on whether what's going through the estate is 100% interest or is it a fractional interest. So in other words, if I own the property and wife and son and I pass away and the property is in the probate process, it's in the process because it can take anywhere from 8 months to a little over a year, depending on how complex the estate is. And it's just inside that 10-year, I either had a will or didn't. We're just going through the estate administration process in the county where the property is or where I live. While the estate is open, there is a creditor's period where creditors can file against the estate, a claim against the person who passed away. So if I passed away and I own Discover card $5,000, $6,000, they can make a claim against the estate, and any property in the state can be subject to that claim. So anytime property is going through an estate, it can be subject to claims against the estate, liens that could attach to the property itself. You're not going to see that sort of buying in and forcing a sale like you would when heirs property is just sort of sitting there and someone buys the interest of an heir. But while property is going through the estate, well, at least inside 1 year. There's another caveat to that law. In South Carolina is really interesting in this regard. If I pass away, and remember, we have 10 years for my wife to file my will or open the estate, to do that traditional form-driven estate administration process. After 1 year, all unsecured creditors' claims are barred, whether my estate is opened or not. So in South Carolina, if my estate is open a year and a day after I'm dead, but still inside the 10-year period, right? The unsecured creditors can make claims against the estate all day long. As the personal representative or the attorney person, I'm denying them because they're outside the statutory time frame to file unsecured claim. Now, that doesn't affect mortgages. It doesn't affect secured creditors. Student loans may be a different matter too, and federal tax liens or state tax liens. But unsecured creditors like credit card folks, that stuff sort of goes away after a year. What if you're 18 and your grandparent left you in charge because your parent is ill? That's basically just the ability, if the rest of the heirs are allowing you to sort of operate in that fashion, you can do so. It's just not a legal, it's not a legal title or legal associated rights, generally speaking, in South Carolina. I see the breakout room is going to end in 30 seconds and counting.
30 seconds, yeah. Any other questions? Oh, you're more than welcome. Thank you, Josh. And thank you, Alexa. This has been very, very informative.
Thank you for having us. I've really enjoyed it. Thank you.
Excuse me, I heard that this was being recorded. Will it be available later?
Yes, it will, if the recording is good. But yes, good question.
You muted, Gloria.
Yes, I see. Thank you. All right, again, thank you everyone for joining us. One of the questions was about the recordings, and yes, we will provide the recordings. We'll probably send you a link to the recordings. I don't know, the files are probably too large to send as an email attachment, so we'll probably send you the link to the recording. The other thing I'd like to mention is that we will send the PowerPoint presentations. Josh didn't use his PowerPoint presentations, but he did send a couple of presentations, he and Alexa, that they would like for the participants to have. And so I'm assuming Josh and Alexa, that's still okay?
Yeah.
All right,
Yes,
so we will
absolutely.
send that. And Terrence, thank you so much. And you sent a PowerPoint presentation. Is it okay that we forward your presentation to the participants? Great, great. All right, so guys, we will forward that to you. Now, we have a request from you, and that is that you complete a survey. After the webinar is over today, I will send you an email with a survey link. And Alexa and Josh, I use the survey that you all provide through the center, and then we have a survey that we use through the links incorporated. And so we will send you the email with the links to those surveys, and we ask that you please complete the survey. We like feedback. It's how we continue to try to provide services that are requested by participants and within the community, by taking a look at the reflection forms to see if there are other areas that you would like to see offered, or if your questions were answered. And if not, we'll certainly get back with the presenters, and you have their contact information, and you can contact them directly if there are questions that maybe we just didn't have enough time. I know in Josh, in your session, the questions started to pop in the last few minutes. So I don't know if we had enough time for all of the questions to be answered, but certainly we will try our best to get back with you. So again, thank you to our presenters today. I want to thank you for our community partners. Rosemary, I don't know if you or if Eugene, if you all have closing comments. And we also have, if you'll stay on for just a couple of minutes, we will have a drawing for 4 $25 gift cards. Okay, and so we will do that in just a second, but I want to hear from our chapter president, like Rosemary, and Eugene, if you're still on with the NAACP, as well as Donna Wesby, if she's still on. I know that there were some other obligations today as well.
Thank you so much, Gloria. Again, I applaud all of our presenters and our partners. You've done an excellent job, and we are so appreciative of the information that you brought to us so that we can share it. with our community.
And I want to echo that. Thanks for everyone to taking the time to participate on this afternoon. There's plenty of things that we can all be doing on a Saturday morning, but getting education about how we can invest our money and how to generate and maintain generational wealth is certainly a cause that is worthwhile. So we're looking forward to the next one. Thank you again to the Aiken Links for putting together this very valuable information. Be safe.
Thank
Yes.
you.
Yes, and again, I'd like to thank the Links and the Aiken County Branch in AACP, all of those who attended this session, all of the presenters. Information provides knowledge, and knowledge destroys ignorance. And we're so grateful for this opportunity to gain some knowledge, and we pray that we're able to use it as well as to share it. And we look forward to working with you all again. God bless.
All right, and thank you all to our presenters, our co-sponsors, and especially to our participants. All right, let me see if I can go to this wheel of names and see if we have a winner. You all probably can't see my screen because I didn't share it, did I? Well, if you'll give me just a second. I hear Kendrick Swinton. Is Kendrick still on? All right. We'll remove that name and we will spin again. Joyce Sheiks.
I'm on.
All right. And Pat, if you or Valencia can help me keep track of the names. And congratulations, Joyce.
Thank you.
Gail Sampson. Gail Sampson. Is Gail still on?
No, that participant is not on.
Okay. Okay, Sherelle Butler is a member of our Links, and so Sherelle, I'm sorry, I should have taken our Links members' names out. So if I'm going to go ahead and spin again. Amy, I'm sorry, Ann Carlisle. Is Ann on?
No,
You
she's
know-
not.
Okay, let me see if I can speed this up. Tracy Corley.
They're not on.
Natalie Woodson. Natalie Woodson. I know that she was on. She asked that last question that Josh, you answered.
She's still logged on.
Okay.
I'm here.
All right. Congratulations, Natalie.
Thanks.
Natalie is also my cousin, and she's logged on from Maryland. Belize Cummings.
I'm here. Thank you.
Congratulations. One more. Tanya Jeffers. Tanya Jeffers?
She's not logged on.
Okay. Diane Tyndall Sutton. Diane Tyndall Sutton.
Not logged on.
You can just save some time and go ahead and give it to me. I'll take one for the team.
Nicole Paul. Nicole Paul.
Not logged on.
All right, they may have left. I should have mentioned that they have to be present to win. And Mary is a member of our links. So I'm going to remove the name and spend one more time. W. Bates.
Well, how about that? I am here.
Yes, and you asked a question in the last session, so I knew you were on. All right, well, we have our 4 winners, and you all will be hearing from our president, Rosemary English. And again, I want to thank you all for joining us today, and I want to say thank you to our technology committee. Malencia Johnson, that you just heard, she's our vice president and very helpful with technology. Pat Lark. And we also had Mary Harden, and our National Transit Services Planning facet, link Kay Coleman, link Stephanie Alford, link Brittany Alls, and link Murtis Brighthawk. Again, this could not be done without a team effort. So thank you to everyone. And we appreciate all of you joining us today. And I hope you enjoy the rest of your weekend. Have a great weekend.
Thank you, Gloria.
Thank you
Thank
all.
you, everyone.